diminishing the impact of what happened in this case. It is a tragic event. But nonetheless, as I understand the rules, and with all due respect to Your Honor, the purpose of bond is to ensure two things. One is that the defendant is going to appear in court at all prior proceedings, and secondly, that the safety of the community be protected in some way as best it can. With respect to whether he's going to submit to the process, as I've already indicated, he submitted to the process twice. I personally drove him there today, as I indicated, right at the noon hour. With respect to whether he's a danger to the community, well, the danger here is not him, but rather the danger was, is well reflected by not only what I'm saying to you here in the report that you have before you, but certainly by all the media that has reported that the danger were the dogs that were involved in this incident. Those dogs are no longer around, 3 of which have been killed by the police, and 1 which was euthanized. So there is no perceived danger on the part of Mr. Lyons. Mr. Lyons has retained counsel. He's been in constant contact with me. I think a reasonable bond is appropriate. And I'm mindful, Judge, that in these kinds of circumstances, in light of the media coverage, in light of the heightened sensitivity and in some respects anger on the part of community members, and in some respects even anger on the part of some dog owners. I've received phone calls from both sides, and I think that we need to focus on the process, we need to focus on the legality of what's taking place here. He's been charged, and we will certainly take efforts to represent his best interest as best we can within the courtroom and within the courthouse, not in the media, not issuing press statements. So I'm going to ask you respectfully to focus on the rule that talks about bond and the factors that the courts consider. And I don't need to tell you what they are. You've known them for years, and you've practiced. And the rule talks about focusing on whether there is a prior criminal record. I've already indicated what the status of that is. There is no record of non-appearance. There is no history of any substance abuse or addiction. There is no history of any mental condition other than his distraught state of mind right now as a result of this event. Certainly, I would not, under any circumstance, diminish the seriousness of the offenses and the charges here. He is gainfully employed. He has been gainfully employed. He reports his taxes. He certainly has members of the community to vouch for him, but for the quickness of the arraignment today, I certainly did not have enough time to muster those individuals. But I can tell you, as an officer of this court who's been practicing over 34 years, I received numerous phone calls of his support. Certainly, the family who was able to make contact with me is prepared also to assist in any type of restriction, and I emphasize any kind of restriction that this court may impose on Mr. Lyons as this case progresses. And there may be other factors, of course, as the rule says, that you can bear and you can consider on his risk of non-appearance or danger to the public. I will not, under any circumstance, request a personal bond. I think in this kind of situation, it is not appropriate to ask for a personal bond, but I am asking for a reasonable bond, a reasonable 10% bond that is within the reach of this individual, so that we can submit to the process and let the facts come out in the court of law as they should.
Counsel, I've heard the representations, and based on the nature of the charges and the seriousness of the allegations, court is remanding your client to the custody of the Wayne County Jail at this time.
I'm sorry, it's a remand?
Remand.
All right. May I respectfully request what the reasons are so that I have an appropriate record to seek review?
Certainly, your counsel's bond is always subject to review, but at this time, it's remand. Step away from the camera, sir.
So is the court not going to give us any specific factors that we're considering?
Not at this time, counsel.
May I approach the bench to return the document?
Absolutely. DDC, we're going to cut away and then we'll be back.
All right. Thank you.